morning, everyone. Today is July 11th, 2024, and welcome to the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong Motan. Every week, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. Jean's on vacation this week, so Natalie and I are holding down the fort. As you all know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And our audiences have been so generous in contributing in honor of our great speakers. Every week, one of my favorite parts of the webinar is when we announce the running total of just how much people have contributed. Natalie, would you please do the honors?
Hey, good morning, everybody. Thanks so much for joining us for today's program. People have let us know about donations they've made to their preferred food banks or the food banks that our speakers have suggested. And today the amount is $593,129.85. So that's nearly 6 million meals provided by our lovely colleagues in the legal industry. Thank you all so much.
Amazing. Thank you all indeed. Today we have another fascinating presentation, Navigating Divorce Mediation, Pitfalls in the Shadow of the Law. In this program, we will demystify and delve into the complex world of divorce mediation, exploring the potential pitfalls that arise when navigating sensitive topics such as custody, support, finances, and parenting plans. Our lead speaker today is Michelle Kern-Rappe, and she will discuss the process she has developed and trademarked, RAISE, to help parties and mediators resolve divorce cases in the midst of high conflict. And Michelle has brought quite a team with her, including, in alphabetical order, Helene Bernstein, Melissa Goodstein, Jacqueline Harunian, Gabrielle Hartley, and Rebecca Leibowitz-Rothman. So, Michelle, I'm going to turn it over to you. Tell us a little bit about the food bank to which you would like people to contribute if they are able. And then on with the presentation. The floor is yours.
Wow, what a wonderful introduction and what a wonderful and worthy cause that we are all so honored to be part of. And we are here today, and we would love and appreciate all contributions to go to the Mount Kisco Interfaith Food Pantry. And I am very grateful to my dear friend, Veronica McGrath, who is very involved here in Mount Kisco in the food pantry. So I want to give a shout out to her. And I want to give a big shout out to my wonderful panel who has volunteered their time in all parts of the country coming on, despite any technical difficulties we were having this morning. A very dedicated and brilliant group and team. And want to thank Resolute for all their support in putting this program together. I want to thank Rebecca Leibowitz for putting the program together. And without any further ado, I would like this wonderful esteemed panel to quickly introduce themselves. So let's start. Whoever wants to introduce first.
Well, in reverse,
Jackie?
In reverse alphabetical order, I'm Jackie Harunian. I'm a family law attorney and mediator in Nassau County on Long Island. And my practice focuses on all aspects of family law. And I would say about half of my cases successfully get resolved out of court, and the other half spend a little bit of time in litigation before they come to their senses. Over to you.
Hi, I'm Gabrielle Hartley, and I'm also a family law attorney who's turned full-time family law mediator, and I am in New York and in Massachusetts. And I mediate exclusively online, and I help people at any point of divorce, whether they're pro se people just starting out, not knowing where to start, or they're in the middle of motion practice and they just want to bring their case to a close. I'm here to help move people in a positive direction through and beyond their divorce. So thank you so much. And I'm really happy to be here with all of you.
Thank you. And next.
I think, am I next, Michelle? Maybe?
Yes,
Okay.
there you go.
All right. Hey, I'm Melissa Goodstein, and I practice in the New York area. And I am a collaborative attorney as well as a mediator, and I'm currently serving as the president of the New York Association of Collaborative Professionals and have been working in the alternative dispute resolution space for over 30 years. I practiced in litigation all for about 2 years before I quickly lessened my hours and segued into a field that I felt more comfortable with, and more importantly, felt that I could more effectively serve the clients that in the way that resonated with my goals and my philosophy and my approach. And so I really appreciate this panel and welcome the opportunity to speak to all of you and to share our experiences and learn from each other and connect.
That's wonderful. And speaking of connection, I think Colleen just connected on.
Yeah, awesome.
Colleen?
Hi, everybody. This is Helene Bernstein. I'm actually traveling up to Boston for the Family Law Conference with the New York State Bar Association. I'm also an attorney. I've been practicing for over 30 years. I also do a lot of mediation and collaborative divorce, and it's a pleasure to be on this panel with everybody. Looking forward to our conversation today.
All right, so now I'm going to throw it back over to Michelle Kern-Rappi, who is the main presenter here. She has extensive experience in the courts as a mediator, and she's going to describe her practice and her method.
Yeah, thank you so much for that, Jackie. And yes, I had been with the court for 35 years. I created the first mediation program in Manhattan Supreme Court, and RAISE was used as a roadmap to transform the litigation mindset to a mediation mindset. And we're going to, unpack that a little bit here in our conversation. And the impetus for this program today was about 20 years ago or so, I'll say. Since I mediated all kinds of disputes, I had a referral from a very concerned matrimonial judge. There was an application before him to enforce an unexecuted divorce agreement where the consulting attorney had reviewed the divorce agreement with the wife and informed the wife, apparently for the first time, about her rights regarding the marital residence, which had been it was an $8 million marital residence inherited from the husband's parents, and they had been living in it for about 10 years. And apparently, when she went over it with the review attorney, it was revealed that she didn't know about any potential rights she may have had in terms of that inherited home. And so she refused to sign. And then the application was made by the husband's attorney. So I'm going to throw this scenario out to the panel because I'd like to hear their perspective. If you were a mediator, how would you have handled this matter? Anyone?
I mean, as the mediator who, I'm sorry, you mean as the mediator who was first hearing this, or the review attorney?
No, not as me, because I'll let you know after I hear everyone's feedback. The judge gave it to me and I mediated this unexecuted agreement, basically from ground zero, we'll say. But I'd like to hear, if you were the mediator, how is the law, involved in a discussion of inheritance?
Yeah, so I mean, the most important thing that I would do as the mediator would be to advise the client to learn what their rights are under the law, no matter, who's listening right now to this, whether you're in New York or California or anywhere in between. The laws are different everywhere, and you need to know what your rights are before you sign on anything. Now, this particular woman in this case sounds like it was fortunate that it had yet to be executed, but had she gone ahead and signed this document, she would have been out of luck. And all too often in mediation, people just want to be done and they agree to things without understanding truly what their rights and obligations are under the law. So my advice would be, as it is when any case that I mediate actually, is, before we get too deep in, really get your education. It is the most important piece.
So that would have been, thank you, Gabrielle. So that would have been, the inheritance would have been something that you educated her on, or would you have advised her at that juncture to go to a consulting attorney, or what would be your method in terms of?
I would tell her that she may or may not have rights to it. I mean, inheritance is a very particular topic. There's a lot of nuance, there's a lot of gray. It is not a one size fits all kind of outcome. And so it would be inappropriate as the mediator, in my opinion, to give advice, only to give the information that, hey, you want to review this and see what a lawyer would say, because you cannot come back and say you changed your mind after the ink is dry, or even after it's applied, even if it's still wet, really.
Interesting. Okay, and Melissa, you're shaking your head. What are your thoughts on this?
Yeah, it's like you really want to, as the mediator, give information and deliver it in a way for the couple to make an informed decision. And certainly there is a role of consulting counsel to advise about how the law would be applied. And I'm also very much interested in what matters to them about this home and what are their interests, what is the equity, because there is equity and fairness in considering, how to consider this asset, but certainly identifying it and flagging it as an issue to resolve, and really hearing their story and why it's important, how this has affected their lives, what they put into it, and their contributions, both economic, and the meaning behind it, and to unpack that and to learn a little bit more about it. And then from there, to develop some options that will meet what their needs and interests and concerns are. And also applying the law, which may be gray, and telling them that too, because gray, in my mind, is an opportunity to reach a resolution that works for this particular couple and what matters to them, and balancing that.
I love that, really focusing on them and their journey and their needs and their interests, and then speaking about it and then referring it out. So Jackie, is there a possibility that the consulting attorney was taking advantage or trying to find a client, or what's the negative impact of the involvement of, if you had someone like Melissa talking about the gray area and being right, and then a consulting attorney comes in and tells her to refuse to sign or gives her rights? What do you think?
Yeah, I'm gonna give an answer that, sorry, there's an echo. Can you mute yourself? Okay.
You're muted, Jackie.
I'm gonna unmute, then you have to wait. You have to. I did. It's so odd. All right, 1 second.
Pete, are you also logged in with a phone? Are you logged in on 2 devices?
I think Michelle and Jackie are in the same place, and so they're getting feedback. So can you go into 2 different rooms? We can't hear you, Jackie.
Yeah. Well, maybe until she sorts that out, maybe.
Okay, so my answer would be, no, it's not gonna work. This is an echo. I'm just gonna change to studio.
Okay. Ah. Yeah.
Sorry for the technical issues here. What I would say is that I would approach this acknowledging that inheritance is almost always separate property. And too bad these parties didn't have a prenuptial agreement or a written agreement that established that this $8 million home really belonged to the husband, which is certainly what his attorney's position is going to be. But since there is no prenup, And since the house, I'm not sure if it's in joint names or not, but let's assume it's not. There are some equitable factors here, and one of them is, did the parties pay a mortgage together over the past 10 years? Did they fix up the bathroom? Did they renovate the kitchen? Are the children living in the home? And do they attend the school district that they need to continue to attend? And what about the wife's rights to live in her home? And all of that has to be definitely part of a gray area, definitely needs to be discussed in that context. But there's also a somewhat mathematical approach that can go towards what was the value of the home when it was inherited, so we can get an appraisal as of that moment. What is the increase in equity? And everyone knows during COVID, houses went up substantially in value. And would it be fair for her to get a portion of that? And more specifically, what money went into the house from marital funds, from the pay down of the mortgage, the taxes, renovations, things like that. And I think that might be one approach that feels a little bit more fair and more logical. Otherwise, you could have a very contested case. And the other caveat I would have is that mediation can be used as a stall tactic, as we all know. Parties can go to mediation, nothing is filed in court, they get conflicting information from their attorneys, and then you end up after months and months with a very unresolved, very messy issue. So I would want to convey that to the parties as the mediator, definitely tell them they need to get some legal advice, but then try to take a fact approach, mathematically speaking, about what was really going on with this house and how to address it that way. And on that note, I'm going to switch seats with Michelle. Okay.
Musical chairs, yeah.
Okay. Okay. So Helene, it sounds like there's a wide range in the level of legal information that a client would receive depending on which mediator they choose. So Helene, what do you tell people in your opening, the first time you meet a couple?
Well, why people go to mediation for the most part is because they want to use the values and the tools of self-determination. They want to be able to decide what the next steps are, what the agreement's going to look like without input from a judge. So that means, as the mediation clients, they have a responsibility to understand the law, and they also need to know the parameters of what a mediator can and cannot do. So in my practice, a mediator is going to provide legal information, and if you determine that advice is needed, especially since this is a particularly difficult issue, that I would push the clients to see a consulting attorney sooner than later. And I also would add that, the mediator and the attorneys should be working together as a team. We're not working against each other. We have the same goal of getting the couple divorced. So the consulting attorney may define the parameters for the mediation client, then to go back to mediation to resolve the issue once they're more informed. And especially in this particular situation, it might be helpful to the whole team to have the attorneys participate in the mediation. So there are a lot of different options here. And in my practice, I'm not shy about clearly making sure the clients understand their options. It's called reality testing. So that's how I would approach it, Michelle.
So that's very interesting. I want to stick with that for a minute. So it sounds like in this case, the husband's attorney didn't reach back out to the mediator, but instead reached out to the court. So how often does that kind of thing happen? And how would you ensure, as you're saying, that that consulting attorney would feel more or less part of the team with you, Helene?
Well, it's a very interesting conversation. Many mediators feel that the consulting attorney may hijack the process. So it's important for the client to understand how they should be communicating with the consulting attorney, to let them know they still want to pursue mediation. They just need the assistance of the attorney. They do not want to go to court. that they want the attorney to assist them in being more effective in the mediation.
So that's interesting, and I like that concept of self-determination. So Melissa, you talked about having that conversation and being guided by the client's needs. How would you approach that beginning conversation
Yeah.
in terms of self-determination?
Yeah, well, just to also piggyback a little bit about what Jackie and Helene were speaking about, I routinely work in an interdisciplinary approach in both my mediation and collaborative practice, which is based upon an interdisciplinary approach. And
For those who are listening who don't understand what interdisciplinary.
So a collaborative process is where you have collaborative attorneys who are retained by each client. You have a financial neutral, you have a financial specialist, a family specialist who come in the capacity as neutrals. And you're all agreeing to sign a participation agreement that just outlines expectations on how we're going to be working together without the threat of litigation. And if litigation has to happen, then there's a recusal of the attorneys as well as the entire team, so that there's a motivation to work from an interest perspective and a perspective of settlement and good faith and transparency, and all principles which really mediation is based upon. In fact, collaborative attorneys all need to have that mediation training, but we're outlining how we're going to work together. And when couples are stuck in mediation, it's good as a mediator to just not only be the facilitator, but to be the support to help them get unstuck. And sometimes it's just not me to help them do that. They need an attorney to come in and advise them. They might need better financial understanding about the complexities and get a better level of a balance of understanding. So a financial neutral we may bring in, or if they're dealing with some core communication issues or parenting issues that they have a differing perspective on, bringing in a specialist, a family specialist in a mediation can also help. So it's helping them get unstuck and to help them move along for them to reach an informed decision. And I outlined that in my first meeting. I always have like a consult meeting in the beginning just to outline services that I offer, whether it's as a mediator, as a collaborative attorney, and if it's litigation, I say that's another process choice. I'm just not the attorney for you for that. And I give them choices and options. It's like a menu, and you pick and choose what's going to be appropriate to help them reach agreement, because at the end of the day, they need to reach an agreement. How you get there in the process and what support you need, I'm as a resource as well as a facilitator in whatever capacity I'm retained. And I'm always on looking out for red flags and where people are stuck, and I'm diagnosing and saying, okay, let's move this along. This is what you need, and meet the clients where they are. Sometimes they need to take a break. Sometimes that stalling or that waiting is sometimes necessary. It's not done necessarily for a negative, but because they're in a space that they need some time. But as long as they're advised to know that that time may be a different cutoff. They have to work out for cutoff date. There's implications legally, and that's why getting the support of the team and having that connection. I like to connect with consulting attorneys on the beginning, just to kind of, say, how are we going to work together here? How are we going to help these clients? And I think that engagement and that connection and communication is so critical.
So I'd like to hear from Gabrielle. She's been shaking her head. I just wanted to say, so that collaboration. So even though it's not a quote collaborative case, Melissa, it sounds like it, to a certain extent, in your mediations, you're treating that consulting attorney in a collaborative fashion, so to speak, by introducing the law and the consulting attorney's role very early on. So Gabrielle, what about you? How do you begin your mediations?
I'm nodding so much because everything Melissa's saying, I'm like, oh my gosh, I practice just like that. I do a whole intro meeting where we're just talking about that we argue over what we want and we resolve over why we want it. And I encourage people throughout the process. And
could you unpack that a little bit more? That's an interesting phrase.
Yeah. So we fight over I want the house. I want $500,000. I want whatever it is you want. I want full custody. Why? What is that doing for you? Well, you might not really care about the house, but you need to be in the school district, or you want to live near your mother, or you're just afraid that you might not be able to provide the same stability. Or maybe you want the house because you think if you're not in the house, the kids aren't going to visit you, right? So if we start unpacking the fears, right, that's so helpful. And just laying out right from the beginning that we're all very fear driven, whether or not, I don't care what you look like, who you are, where you're from, like we're all afraid, insecure, anxious. Most people haven't been through the divorce more than one time before, and they're coming into the room, whether it's a virtual room or a real life room, they're intimidated and they're got their backs up. And I try to just normalize, we're going to be asking for things and we're going to resolve around motivations, right? So really our deepest needs. So that's number one. The other thing I talk about in the introductory meeting are the destructive behavioral tendencies that we all have. We minimize, we catastrophize, we stir the pot. There's like a list of 5 of them, and I kind of unpack it and I just try to normalize it. So they're not like, oh, she's doing it again. And I let them know I do this too. We all do it when we're afraid, we act out, we're just people. And I just try to like tamp it down. I wanted to respond to a very real issue that Jackie brought up, which is that people may often use mediation as a stall tactic. And I actually, I litigated for a long time. And for many years, I was really aware of that. I think because I was so in the litigation world, like your mindset is just a bit different. So what I did to sort of counteract that and to keep things on track, I took a page out of the judge I used to work for's book, and I created sort of these blitz mediation packages where, you prepay a certain amount of money for a certain amount of time, and it's use it or lose it. There's no hourly, whatever. The whole point is nobody walks away. Everybody uses it, and it's limited in time and space. And since I've started to do that I started it like just before COVID. And it's funny that it like wound up working out past COVID. People don't walk away from money because it's not like it's cheap or free. It's reasonable, but like it forces them to become engaged. Now, I'm sure there's the aberrant person who won't care and will just still use it, but that has anecdotally not been my experience. And I do think that when you are mediating, make sure that the other side, to Jackie's point, is actually interested, or at least interested in exploring the concept of working things out so that more money stays in your household and not going out to the professionals. And the one last thing I just wanted to say really quickly is any of the things that we're talking about here, we all do practice in New York. I also practice in Mass, and I don't know where others practice. But remember, when we're talking about law, that is New York law that we're mostly talking about. And that's why it's so important that you really understand, because I know your listeners are probably everywhere, that you understand how important it is to get local counsel, even for an hour or two. Your mediator may be a seasoned divorce lawyer who's been to court 10 years ago lots of times, but it may also be somebody who doesn't really know what the court is doing. And by talking to somebody who's really in the courts where you live, you're going to have the best insight of what you're giving up before you give it up. And I'm all for giving stuff up, but you just have to understand what you're giving up. Okay, I'll be quiet. Thank you so much.
No, that was wonderful. And I'm going to say a mediator who doesn't know what the court is doing and different courts doing different things. Let's talk about child support and what are the things that are important when you're having that discussion? Anyone? In terms of the law.
In terms of the law, the clients need to know that there is a Child Support Standards Act in New York, and that regardless of what you agreed to, the court needs to be convinced that the clients know what the presumptive amount of child support is going to be under the law. And if they don't agree to it, that's called deviation. They need to know why, and the court will look to the particular factors stated in the law as to why the parties, the parents, have decided to deviate from the law. So that's a conversation that needs to be had at every mediation. And typically in my mediations, we're going to work on what the custody arrangements are first, because that will serve as the predicate for determining what the child support arrangement will be. And I just also want to say, in terms of the use of mediation, even if there isn't an agreement, it is an opportunity to communicate with one another, learn from one another. And so the success or failure of a mediation, in my view, or my training, doesn't necessarily mean whether you come to an agreement. Uh, and I find that most clients are interested in trying mediation now because, especially in New York, there is a presumption that clients will attempt mediation once they step into court, unless, of course, there's domestic violence or other reasons why there's an imbalance of power. So I tell clients, you might as well try mediation before you even step into court, because the first thing a judge is going to ask you is whether you even want to try mediation. So, getting back to the issue of child support, it's a perfect place prior to walking into court to learn what's important in terms of the child's needs, what everybody is representing as their income. These are all conversations you need to have in order to determine what the appropriate amount of child support is.
Thank you, Helene and Jackie. I'd like to ask you, what is the appropriate conversation you need to have if a client is saying they want, joint custody and you're having, and you're having the impression that that may not be the case.
All right, so my practice is in Nassau County, as I mentioned, we're Long Island firm. So we're dealing with a lot of homeowners. And the school district is a very big aspect, as I'm sure it must be in other counties as well, close to New York City. And there is a growing interest. I'm almost shocked at how many clients are suddenly interested in 50-50 custody. It's like the word is getting around. It's very popular. And actually, moms that used to really hold on to that primary role are more and more open-minded about joint custody and actually 50-50 custody. And they tell me that they like having time away from their children. So I don't know, maybe that's what it is. They like having that free time. And we all know that a third of breadwinners are now women, and they're out there earning. And we saw a big surge in income for women after the pandemic. So 50-50 custody can be very problematic, though, because when people come to me for mediation and they tell me they want 50-50, I'm like, great, that means you really get it in terms of parenting. And those are lucky children. Then they tell me that they earn about the same. I'm like, oh my God, that's really great. We're going to be able to probably resolve child support without too much controversy. And then they tell me that their income is W-2 and very easy to document. Well, that's a home run when it comes to child support, because in a 50-50 situation where both parties earn about the same, we're looking at a sharing of costs across the board. Probably no payment of child support from one parent to the other. But they're going to share the so-called add-on expenses. And it's very important that clients in mediation understand all the various components of child support. It's the monthly amount, it's the add-ons, it's the medical insurance, it's college bills one day and credits, and then activities and things. And so this is obviously an issue of very big concern. I tell clients that child support can be modified. There really is no such thing as a final child support order. There are grounds for modification, and now we have new guidelines regarding opting out. All of this must be carefully explained, even in cases where parties get along really well, and if their income is straightforward. Which brings me to what happens if their income is very far apart. What happens if their income is not documented and one of them owns a business, which can be a very complex issue in mediation sometimes. So those are the cases that are going to take more counseling. Definitely, they need to share information about income. If they have joint tax returns, that needs to be explained. The pitfalls of challenging your own tax returns in court. The judges don't love that. And then also, how do we build that trust and that sense of fairness so that the children's needs are met and neither party feels like they're getting the short end of the stick when it comes to support? If the incomes are very far apart, we're also going to be talking about spousal support. And I find the problems I'm seeing now, as wonderful as joint custody is, are the cases where, and I have to say it, fathers are very motivated to go to 50-50 because they want to get child support, because their spouses are earning more. And it's only fair, right? The laws are gender neutral, and why shouldn't a father get child support? But there's a lot of resistance and not always clear on what the motivations are. I am starting to see cases where fathers agree to 50-50, get a great support outcome, and then they don't have the kids 50-50 after the fact. Suddenly the mom is taking care of the children more, or the children don't want to go to the father. And of course it could be the other way too. So this is something where, as a mediator, I want to make sure that the 50-50 is legit. It's what both parties really, really want. It's, in the case of teenagers, they're actually going to leave the house and go to the other parent's house. Becomes an issue if they're living in the marital residence. You have to really explore it. Make sure there's language in the agreement that protects both parties in the event a modification is needed. And for 50-50 custody, make sure the support terms are fair and reasonable and serve the children the best. You see a lot of parties in mediation that have unreported income and things going on tax-wise, and they just want to go to mediators so that they can wrap it all up without too much scrutiny by the court. And those are problematic, because those people are going to end up back in court. I've had 2 or 3 cases where the parties have agreed that the children live with the father in the marital residence, but the mother is getting child support. And that's not logical. And mediators are writing agreements like that. And I don't even know how they're getting approved by the courts. And so, of course, there's going to be litigation in cases like that, because it doesn't match the reality. So there are certainly pitfalls in the joint custody and child support area. Overall, though, I think it's a great trend, and I think it's going to lead to more mediation, because parties want to agree on that, and we have to find ways to make it work for them. Okay.
Yeah.
Oh, well, I'd like to hear someone else's comments in terms of add-ons and continuing this discussion, and what are the add-ons anyway? And if someone could comment on that, and what are the things that may not be an add-on, but something that you personally feel it's important to have that discussion. So who would like to add? Melissa?
Sure. So I think also it's really important to really define what terms mean to each of the participants in the couple. 50-50, you hear that all the time, but what does that mean? What does that look like? And really unpacking terms, because there's a lot of, advice outside of the process that people are saying, oh, go for 50-50 because, then there's no child support. Well, what does that really mean? What does that look like? What's possible? What's realistic here? And I think understanding and getting to a better understanding about what these terms mean to each other, and what they mean, and what they mean by that, and what each of them understand the other person to mean about that, is really, really an important conversation to have. And also just going back.
What does that mean?
I want 50-50, like, you want, well, what does that mean? You want the children, 50% of the time. Well, what's your work schedule like? Where are you living? And then when you unpack it, they're like, well, I just want to see them like at least 2 nights a week for dinner, and then on the weekends. And I'm like, okay, well, let's structure a parenting schedule and an access schedule that reflects what your intentions are and what you hope to work towards in terms of an access that feels right for you and right for your family and right for your kids, and just defining terms and what reality is going to look like for that family, because each family is unique. Add-ons are unique for each family. I mean, there's categories, but some categories might be a category for one family and not for the other.
I'm going to stop for a minute because I promised the RAISE. So it sounds very similar to the RAISE roadmap that I created in Manhattan Supreme Court. It sounds like we both take the couple down that same trajectory, as recognizing interests and then digging deep into, actively listening to that particular couple about, what 50-50 means, gaining insight from them and coming up with solutions, more, less characterizing 50-50 and going deep into the personal interests of that couple. Like, what does it mean? Oh, it means a weekend. Okay, so then what is that? And as you dig deeper, there's a certain level of truth that emerges of this couple, and then therein lies their agreement. So
That's
it's very, very similar to the Rays roadmap, but yeah, go on.
Yeah, for sure. It's just checking in. Each family again is unique. There's not like a rubber stamp. This is what an add-on. I mean, there's categories of mandatory add-ons, right? There's in New York at least, and we can go into it. And there's more discretionary. And discretionary is opportunity to kind of put, okay, this is the agreement we're going to have, and maybe it's going to change. So you build in flexibility and ways that things are going to be modified and reevaluated to try to make that agreement compliant with what is going to be. You need to recite what the guidelines are in child support in every agreement, so that any deviation or application of the guidelines is going to be approved by a court. And that's the balancing that always a mediator is doing and structuring and helping the clients reach an agreement with the help of this team.
Oh, thank you. But Gabrielle, I just wanted to get in because I know we're getting close to the end. So you worked in the courthouse. What's your court view of looking at add-ins? How closely do you look at it, or the discretionary, as Melissa said?
So, it's really funny that you just said, because you worked in the court, because I was thinking, like, I do have a little bit of a different perspective. I guess we all do. We've all been doing this a really long time, but in slightly different ways. So I'm loving listening to what each of you have to say. I will tell you, working in the courthouse, the biggest problem, it's not on all of these little details that we're talking about. The biggest problem are agreements to agree, which are not enforceable. So people make agreements, and yeah, of course, there's the aberrant case where somebody didn't understand what they were saying, and and that's a big litigation. Yes, that does happen. But the thing that comes to my mind as the biggest problem is people go to mediation, they want to save money, they want to do it quickly. They're like, oh, we'll work it out. They're not thinking about, oh, you can't stand her new boyfriend, his new wife, whatever. Like, you're jealous about this, that, or the other thing. Your kid has a problem. You don't agree on how to do something. And you have this loosey-goosey language. And then guess what? You're going to find yourselves in court. Okay, so now Jackie and I are speaking the same language, right? So like, because everybody has rose-colored glasses. Oh, we can still be friends. And it's just important not only to address the issues, but also when you're doing a parenting plan, that you have all of the child's time accounted for, meaning drop off and pick up. Like I do, like, 8 a.m. or 3 p.m. or whatever it is, have it coincide with the school day or something that's really clear, clean, and logical. Because if you have anything that is left to determination and there's no rule book, no process to fall back on, and you're in no man's land, that's where problems start to arise. That doesn't mean that you're going to arrive at a perfect agreement. That doesn't mean that you have to rigidly adhere to every term of the agreement as written. But you want to have, I always tell my clients, rules for the road for when things go a little bit off track. So in order to file a contempt, you have to have, what is it, a clear, unequivocal, I can't think of the exact language, clear, unequivocal, enforceable language. And if it's not clear, if you're punting, you're going to wind up with a problem. I can see Melissa's trying to.
Aline, any comments on that? Thank you.
Yeah, in terms of add-ons, the whole issue of college expenses, I think about what all of the panelists said today. Especially when you have a younger child, it's very vague language. And then all of a sudden the child is 16 and the judge is like, an agreement to agree is nothing.
Mhm.
And of course, that could be the biggest expense in a child's life. And here, couples went through mediation without any clear understanding of what the obligations are. So that's one area. Another area where it's not specified, and I've had this issue in court, is where agreements do not cover the cost of living adjustment. That is.
Oh, Helene, you're cutting out. All right.
All right.
I think we're almost running out of time. I wanted to just throw out to the panel. This has been so excellent. Helena, how do you handle power imbalance?
The add-ons are. And,
all right. I think she'll still go in at the add-ons. Yeah. All righty.
You know what? I would like to
I'm
ask.
sorry, do you hear me now?
No, but how do you handle power
Stable
imbalance?
network connection.
Last
If I do that well.
question. How do you handle, I know in
I-
collaborative, you have
Sometimes,
professionals, but as a mediator, how do you handle power imbalances? Anyone?
well, sometimes I'll use the tool that's called the caucus. I may speak with each party individually to understand where they're coming from and to see where there's been some communication issues. And I need to make an assessment whether mediation is appropriate. A experienced mediator is not afraid to say mediation is not the right process for the couple. And so it does take a deeper dive into understanding everybody's capacity and everybody's willingness to share information.
Yeah. Yeah, I agree. Also,
That's a
just
great
you're,
point. That's a great point. Okay.
yeah, because you're making an assessment. It's really important to like read the room and to look at body language and how people process information differently, and you need to be sensitive to that. Sometimes people like are very visual learners. Some like really need time to process like what are their different styles and personalities. And I think when you connect, I always like to kind of get that better understanding and connection with my clients to really understand, what are their, how do they learn, how do they process information, and if there's a power imbalance, how to correct that. What's a tool? Like, is it having a more work with the consulting council to help them get a better understanding about what their rights and obligations may be? Is it to bring in a financial person, either individually for that person or in the mediation as a neutral to get a better financial understanding and also, so it's just tools and resources and diagnose
But
and
would
figure
it be a coach or something like that?
no, it would be maybe an individual financial advisor, maybe that they would have, or a financial neutral to come in, or maybe it would be a coach. Maybe there is a family specialist that needs to come in and help them manage the emotions. Maybe they can't hear because they're just, or their own therapist, getting their own support. People are not ready to process and listen. You have to listen before you tell, right? You have to hear what's going on and their capacity to receive the information and support to help them get there.
Well, I thank you very much. I think this may be it. We're at the end of the hour. And I want to thank Jack Kitchabin and everyone from the Will Work for Food group.
Michelle, thank you so much, and thank you for bringing such a qualified expert team with you to explore these issues in great depth. And we know that we'll be generating a lot of contributions for food banks as a result. And I know that it's the Mount Kisco Interfaith Food Pantry where you'd most like people to contribute if they're in a position to do so. I know I'll be contributing there in your honor, and I know many others will as well. Thank you very much for this presentation. All of you, the whole team. We've never had such a big team before on Will Work for Food. It really paid off. Thank you all so much. And with that, we are complete.